One of the more significant public employee First Amendment free speech cases is a case called Garcetti versus Ceballos. Traditionally in public employee free speech law, there was a two-part test called the Pickering-Connick test. Under this test, a public employee had to show that his speech touched on a matter of public concern or public importance, as opposed to a private grievance. If the speech touches on a matter of public concern, then we balance the public employee's right to free speech against the employer's right to an efficient, disruptive, free workplace. The U.S. Supreme Court changed that in Garcetti versus Ceballos. It involved an assistant district attorney named Richard Ceballos, who learned from a criminal defense attorney that there were problems with the search warrant affidavit in one of the office's criminal cases. The defense attorney warned Ceballos that the sheriff's deputy had perjured himself. Ceballos did a little bit of investigation and came to the same awful conclusion. The search warrant affidavit contained false testimony. Ceballos wrote a memo to his superiors recommending that the criminal charges be dismissed because of the perjured law enforcement testimony. His superiors disagreed, however, and criminal charges proceeded in the case. After his speech, Ceballos was demoted and transferred to a less desirable office location. Ceballos sued, alleging First Amendment retaliation. He contended that his employer retaliated against him because they didn't like what he had to say about the search warrant affidavit. Traditionally, under First Amendment public employee free speech jurisprudence, Ceballos had a good chance of prevailing. After all, he spoke about a matter of public concern or importance, and his free speech rights certainly would have outweighed the employer's interest in an efficient, disruptive free workplace. But the United States Supreme Court created a new rule. Writing for a bare 5-member majority, Justice Anthony Kennedy wrote, "When public officials make statements pursuant to their official job duties, they are not insulated from protection by the Constitution, and they have no First Amendment protection." The court emphasized that it was Mr. Ceballos' job to write the memo. The decision has had a disastrous impact on public employee free speech claims. If a public employer can show that a public employee engaged in official job duty speech, there is no First Amendment protection. It doesn't matter how important the speech is. It doesn't matter if the public employee is a true whistleblower. All that matters is if the public employee engaged in official job duty speech.